Hello, I'm still Tim Hannon, and I'm here to to guide you through the chapter on mechanics lien law. Let's begin with page 1, a very good place to begin, don't you agree? I'm going to be giving you an introduction to these three remedies for not getting paid, namely the mechanics lien, the stop payment notice, and payment bonds. Now, let's talk about the phrase mechanics lien. Hundreds of years ago, a mechanic was regarded as somebody who worked in the construction trades. A bricklayer, a stonemason, a carpenter, a plumber, a roof thatcher. Nowadays, we tend to think of a mechanic as somebody who works on an automobile engine or an airplane engine. And of course, they didn't have automobiles and airplanes back in those days. Nevertheless, the old phrase mechanics lien remains. The term mechanic refers to somebody who works in the construction trades, and the word lien, L-I-E-N, is an old Anglo-Saxon word meaning some kind of a legal right. So if we were to translate the term mechanics lien into modern English, the term would be contractor's right. Okay, so far so good. Contractor's right to do what? The mechanics lien is the right of a contractor or subcontractor or supplier to take his pay, if necessary, right out of the value of the property that he's been working on, if he doesn't get paid by whoever hired him. So if the general fails to pay the sub, or the owner fails to pay the general, or general or sub fail to pay a supplier, that unpaid person has a right to resort to the mechanics lien. It's important to remember that the mechanics lien only takes effect once the contractor or the subcontractor or the supplier has actually furnished labor and materials to the job site. In other words, the mechanics lien, the right to get paid out of the property itself, does not spring into being until the claimant has actually done something to improve the property. He has to have gotten his hands dirty, broken ground, done something to improve the property before the mechanics lien arises. You might regard the relationship between the mechanics lien claimant and the property as what they call in nature a symbiotic relationship. That is to say, they help each other. The contractor works to improve the property, and the property in turn stands ready to provide the contractor with a means of getting paid for his labor and materials. All right, now let's move on to page 2, the stop payment notice. This is a remedy for not getting paid, invented by the California legislature in 1969. Much more recent vintage than the mechanics lien. The idea here is that subcontractors and suppliers need their own special remedy for not getting paid. And they have this special remedy in the form of the stop payment notice. The mechanics lien is, as we mentioned, targeted at the property itself. That's the target of a mechanics lien. Unlike the mechanics lien, the target of a stop payment notice is the money. If there's an identifiable fund of money being used to finance a construction project, that's a good target for a stop notice claim. Or I should say a stop payment notice claim. Typically, a construction lender will be holding the money for a construction project. If a subcontractor or supplier does not get paid like he's supposed to, he could send a stop payment notice to the lender, whoever's holding the money, and that lender would be obliged to set aside the amount of the stop payment notice claimant's claim, set it aside for him, while the claimant goes to court and persuades a judge that he is indeed entitled to that money. There's a similarity between the mechanics lien remedy and the stop payment notice remedy in this sense. Each of them provides a means by which the claimant can collect if he's successful in court. In other words, The mechanic's lien claimant can rest assured that if he wins his case in court, if his claim is upheld, he will be paid by means of the proceeds from a forced sale of the property. With respect to the stop payment notice, the claimant will be paid if he's successful in court. He will be paid out of the money that has been set aside for him by the holder of the funds. Further on page 2, we have payment bonds. A payment bond is a guarantee from a bonding company, a surety company, that if the contractor or subcontractor fails to pay his workers or his material suppliers, the bonding company will step into the shoes of the contractor or subcontractor failing to pay. The bonding company will pay the workers or pay the suppliers. Then the bonding company will turn around to that contractor or subcontractor and say, we had to pay your bill for you, now you have to reimburse us. That's the essence of a payment bond. Let's move on to page 3. You have there a guide on how to go about counting the days before a deadline sets in. The law imposes several deadlines on contractors with respect to pursuing their mechanic's lien remedy, as you will see later on in the lecture. It bears mentioning, actually you should highlight the first sentence in the third paragraph on page 3. It reads, "The most common reason contractors are deprived of their mechanic's lien law rights is missing a deadline." Yes, indeed, that is so true. The mechanic's lien is a fragile right, sort of like a crystal vase, in the sense that if you drop it and break it, you can never put it together again. Likewise, if you miss one of these deadlines for doing a mechanic's lien claim, you can never get the mechanic's lien right back again. And it's so important to you to preserve your mechanic's lien right. Let me explain it this way. There are basically 3 hurdles that you have to overcome in order to make the law operate in your favor. I call those hurdles liability, damages, and collectability. Liability means that as the plaintiff you have to show that the defendant owes you money. Damages means that it isn't enough just to show that the defendant owes you money, you have to prove how much he owes you as well. If you overcome those 2 hurdles, liability and damages, you get a judgment in your favor. You win your case. Tra-la. There's still that 3rd hurdle to overcome, collectability. You see, when you get a judgment in court, that judgment is really still just a piece of paper. In order to transfer that judgment into money in your pocket, you have to be able to collect on the judgment. And that's where the mechanic's lien comes in. It solves the collectability problem for the contractor who didn't get paid. Once he has a judgment from the court, it'll be an easy matter for the contractor to execute on the judgment. That is to say, to get the sheriff to hold a sale of the property, collect the proceeds of the sale, and pay off the mechanic's lien claimant from the proceeds of the sale. But for that to happen, for that collectability problem to be solved so easily, the contractor has to preserve his right to the mechanic's lien. So don't miss a deadline. That's the lesson here. Moving over onto page 4, mechanic's lien law does require that you give certain notices at times. We'll get into the details later on. But at the bottom of page 4, you have minimum information that needs to be included in a notice. Now let's go to the top of page 5. I'd like for you to highlight the first sentence there, reading, "A notice may be served by personal delivery, by leaving it at the recipient's home or business with someone in charge, or by registered certified mail return receipt requested." You should highlight that first sentence there. Personal service means that you have this notice required by mechanic's lien law handed to the person to be served by some adult person, that is to say somebody over the age of 18 years. Just walk up to the person to be served and hand it to them. That's personal service. The other method is service by certified mail return receipt requested. There, the postman delivers the notice, and when he delivers the notice to the person to be served, he has that person sign a little green card that rides on the back of the envelope containing the notice. And that green card goes back through the mails to you, the sender. And when you get that green card with the signature on it, that's all the proof you're going to need in court that that person was indeed served with the notice on the date that it was served. I favor serving by certified mail return receipt requested, because that way you don't have to rely on some other person to be available to testify in court if it ever comes to that, if you ever have to litigate. Further on down the page, you should also highlight right in the middle of the page, it reads, if a notice is required to be posted, it must be placed in a conspicuous location at the site, and the notice is considered to be served at the time it is displayed. Toward the bottom of page 5, we have a section headed prior to serving notices. This itemizes information you should gather actually before you even make your contract, because you're going to want to know some fundamental things about the property you might be working on. Who owns it? What liens are there against it? In fact, it would be a good idea to get familiar with the recorder's office, where the histories of all real properties are kept in the county, and look up what information is available at the recorder's office about the property you're being asked to work on. You'll want to know, for example, whether or not that property is already mortgaged to the hilt. If there's more debt on the property than the property is worth already before you even start work, then your mechanic's lien remedy isn't going to be worth much, because all those other creditors will be ahead of you in line to get paid. So if you're being asked to work on a property that you're not familiar with, work with people that you haven't worked with before, it would be a very good idea to do some research into the history of the property and find out whether or not there's more debt against the property than there is value. You certainly don't want to put yourself in a situation where you do a lot of work and then you can't get paid for it. Sometimes it's necessary in business to be successful. Sometimes it's necessary to say no to a proposal or a project. Flipping over to page 7, preliminary notices. The preliminary 20-day notice. This is a prerequisite. It's step 1 for subcontractors and suppliers, whether they're going to be pursuing a mechanic's lien claim or a stop payment notice claim. Take a look at the diagram at the top of page 7. It's a very useful diagram. You'll note that the preliminary notice is served by the subcontractor or supplier. It's served on the prime contractor and the owner and the lender if there is one. The basic idea behind the preliminary notice is this. We've noted that the sub or supplier has automatically, by law, right to a mechanic's lien. That is to say, a right to collect against the property he's furnished his labor and materials to if he doesn't get paid by the general contractor like he's supposed to. Okay. That's a very powerful remedy that the sub or supplier has to get paid. And of course, the target of the mechanic's lien, potentially, is the owner's property. Well, it's only a matter of fairness for the subcontractor to let the owner know that the subcontractor is working on his property and has this right, this powerful right called a mechanic's lien. I mean, after all, if it weren't for the preliminary notice, the owner wouldn't even know who the subcontractor is, chances are. If he met the subcontractor in the vestibule of the church on Sunday or in the produce department at the grocery store, he wouldn't know who that subcontractor is. It wasn't the owner who hired the sub, it was the general. And yet, if the general fails to pay the sub, the sub has this powerful remedy to resort to the owner's property. Pretty rough on the owner. So as a matter of fairness, the law requires that when a subcontractor starts in with his work, he has to let the owner know that he's working on his property and has this mechanics lien, so that the owner can keep close watch over the general contractor, make sure the general pays the sub, so this bad thing won't happen to the owner's property. That's what the preliminary 20-day notice is all about. It's a friendly warning to the owner before anything goes wrong that the sub has this powerful remedy called the mechanics lien. It's only fair to let the owner know what the rules of the game are at the beginning of the game, not at the end of the game. Make sense? Let's go to the top of page 8 now, where it says, a subcontractor who does not serve a preliminary notice loses both stop payment notice and mechanics lien rights. Very important sentence. Please highlight that. And let me now direct your attention to the sample of a preliminary notice on page 8. It's a one-page form with a lot of legalese on it. Let me translate this into plain English, if I may. The preliminary notice says basically this. It's a message from the subcontractor or supplier to the owner of the property saying, hey, Mr. Owner, I'm a sub or a supplier who's been hired by your general to work on your property, and I just want you to know, as I'm starting in with my work, that I have this powerful right called a mechanics lien, which entitles me to, if I don't get paid, it entitles me to go to court and get an order forcibly selling your property out from under you so that I can get paid out of the forced sale, the proceeds from the forced sale. I just want you to know that, Mr. Owner. Fair warning is fair play. Do keep a watchful eye on your general. Make sure he pays me so this bad thing doesn't happen to your property. Over on page 9, we have a letter worded in friendly language addressed to the owner, saying in effect, hey, Mr. Owner, this legalistic-looking notice, this preliminary notice, don't be alarmed by it. My lawyer made me do it. It's just a routine notice. Nothing's wrong. I just need to apprise you of my mechanics lien rights. That's all. At the top of page 10, we have comments here about the preliminary notice for private works. A private work means non-governmental work, as opposed to a public work, which is some project done for the government, either the state or local government. The second paragraph on page 10 reads, anyone improving private property without a direct contract with the owner must serve a preliminary notice. You notice that we've been stressing that the sub and the supplier have an obligation to serve the owner with a preliminary notice. What about the direct contractor? Direct contractor does not have to serve a preliminary notice on the owner. He can skip step 1, in other words. Why is that? Well, because the general contractor already has a direct contract with the owner. By definition, he's sat down with the owner and made a contract with the owner. Nobody needs to tell the owner that the general is working on the owner's property. The owner knows that by virtue of the fact that he's directly hired the general to do that very thing. Moving farther down the page, on page 10, preliminary notice must be given to the property owner, the direct contractor, and the lender if there is one. In addition to general requirements for notices, which we went over earlier, private works preliminary notice must also include a description of the work, an estimate of the total price, and the following statement in bold-faced type as illustrated at the top of page 11. There's the notice to the property owner. Further on down the page, on page 11, we have some comments about preliminary notice for public works. Here again, the idea of the preliminary notice is to let the government agency hiring the work know that the subcontractor may have to resort to his stop notice remedy if he doesn't get paid by the general. Over on page 12, there's a comment there that deserves to be highlighted. It reads, "A claimant who fails to serve a preliminary notice loses the right to a mechanics lien and stop payment notice. So it is often recommended that you serve this preliminary notice on the day you start work, just to make sure you do not forget and miss the deadline for filing." Let me expand on this a little bit. What if the subcontractor is late serving his preliminary notice? On a public project, that is to say a government job, you cannot serve a preliminary notice late. You have to serve it within 20 days of first furnishing labor or materials to the job site. On a private project, a non-government project, the subcontractor can serve a preliminary 20-day notice late, but it only relates back 20 days worth of time, so that if the subcontractor first starts work on July 1st, doesn't get around to serving his preliminary notice until August 1st, that preliminary notice is only going to relate back to July 10th, so he can only get his mechanics lien and stop notice remedies if he needs them for the labor and materials he furnished from July 10th to the end of the job. For whatever labor and materials he furnished from July 1st to July 10th, all he's got is the right to sue for breach of contract, and good luck collecting. Now let's move on over to page 13, the mechanics lien. The first sentence deserves to be highlighted. The purpose of a mechanics lien is to provide real estate as security for the payment of unpaid bills for goods and or services. As I was explaining earlier, the mechanics lien solves the collectability problem for the unpaid contractor or subcontractor or supplier. If the unpaid claimant is successful in court, and he gets a judgment in his favor, he's not going to have to worry about how to collect on the judgment. All he has to do is turn to the sheriff of the county, have the sheriff, pursuant to a court order, forcibly sell off the property, and then the sheriff will turn around and pay out of the proceeds of the sale whatever the claimant has coming to him. Who's entitled to a mechanics lien? A licensed direct contractor, a licensed subcontractor, material suppliers who can prove that their materials were incorporated into the structure, and lessors of equipment. They're all entitled to the mechanics lien remedy. Now, if you're a direct contractor, a prime contractor, you have to wait to record your mechanics lien until the end of the project. If you're a subcontractor or material supplier, you may choose to record your mechanics lien anytime you sense the need to. So when may that be? When do you reach for the mechanics lien form, fill it out, and record it? The answer to that question, when do you assert the mechanics lien? The answer to that question is more artful than scientific, I have to tell you. But basically it comes down to this. If you're not getting paid like you're supposed to be getting paid, and nobody seems to care all that much, then it's time to get serious. Let the other people know that you are to be taken seriously as an earnest business person. You might think of it as hoisting your "Don't Tread on Me" flag when you record the mechanics lien. So what does it mean, recording the lien? What does that entail? If we go to the top of page 14, we find some comments there about how to go about recording a mechanics lien. There are 58 counties in the state of California, and each one of them has a political capital called the county seat. Just as Sacramento is the capital of the entire state of California, so each of the 58 counties has a capital city, you might say, called the county seat. And in that city are located all the county offices, including the county recorder's office. What goes on in the county recorder's office is this. The county recorder has available to the public, for anyone to view, the legal history of every single parcel of real property within that county. Every single tract home, every commercial property, every orchard, every piece of real property in that county has 10 or 20 or 100 or 200 pages devoted to it at the county recorder's office, stretching all the way back to the 1870s sometime when California started keeping records of real properties. When you record your mechanic's lien in the county where the property you've been working on is located, when you record your mechanic's lien at the recorder's office, in effect, you're putting the whole world on notice that you have a claim against that property. And that's a very significant moment, because anybody who comes into the recorder's office after you do with a claim against that property is going to have to get behind you in line to get paid when that property is eventually sold and the proceeds of the sale are divided among those who have recorded claims against the property. So that's the importance of recording your mechanic's lien. You let the owner and the general contractor know that you're to be taken seriously, and you establish your place in line to get paid when the property is eventually sold. Further down on page 14, we have a section headed Requirements. The first sentence should be highlighted. It reads, "A notice of mechanic's lien and an unfiled copy of the lien claim must be sent to the owner before the contractor may file the lien." And you've got on pages 16 and 17 examples of a notice of mechanic's lien and the mechanic's lien form itself. The mechanic's lien form has to include the amount of money owed to the claimant, the name of the property owner, description of the labor, services, and materials supplied to the property, the person who employed the mechanic's lien claimant, whether it be the owner or the general. The property being liened has to be described. A street address is sufficient, although it's better if you make that not only a street address but also the lot and block number, the legal description, as they say. The claimant's own address, of course, has to be included, and a proof of service affidavit proving that the owner was indeed served as he was supposed to be with the lien claim. And then finally the following statement on page 15, notice of mechanic's lien, in bold print. This is an important requirement. Oftentimes, when the owner receives notice of the mechanic's lien in this prescribed method, that will lead to a quick remedy without your having to go farther. Particularly if you're a subcontractor and the owner receives notice of mechanic's lien. If he doesn't already know what a mechanic's lien is, he'll turn to his lawyer. The lawyer will explain, well, this subcontractor is claiming he wasn't paid and he's about to foreclose on your property, Mr. Owner. At that point, the owner usually becomes the staunch ally of the subcontractor in getting the subcontractor paid, because of course the owner doesn't want to run the risk of losing his property. Moving over onto page 19, under the heading Lien Release Bond, the first sentence of the second paragraph deserves to be highlighted. It reads, "An owner whose property has been liened has an important counter strategy. The owner may free the property from the lien by posting a bond equal to 125%, or 1.25 times the amount of the lien." Yes, there may be times when an owner challenges the amount or even the validity of a mechanic's lien recorded against his property, but he doesn't want to have to remove the lien by paying off the claimant. Instead, he can go to a bonding company, a surety company, and purchase what is called a lien release bond, the effect of which is to take the mechanic's lien off the title to the property and substitute the bond in place of the mechanic's lien, so that if the mechanic's lien claimant is successful someday, he could collect against the proceeds of the bond rather than proceeds from a forced sale of the property. Very handy remedy for the owner to have if he needs to free up his property from the lien and doesn't believe the lien is valid. Further on page 19, stop work order. The Civil Code does give a direct contractor the right to serve a 10-day stop work order if payment is not made by the owner or the owner's lender within 35 days of a due date specified in the contract. Then if the payment is not made within 10 days of service of the stop order, the prime contractor may stop work without being regarded as breaching or violating his contract with the owner. That's a handy tool to have if you're having trouble getting paid by the owner. And now we're on to page 20, where we will take a detailed look at stop payment notices. The last sentence in the first paragraph on page 20 deserves to be highlighted. It reads, "Mechanics liens and stop payment notices are both ways of securing payment for unpaid construction debts, but they are distinct and separate actions." Well, there are similarities and differences. The procedure for doing a mechanics lien claim is essentially the same as the procedure for doing a stop notice or stop payment notice claim. The first step is the same, the preliminary notice. The preliminary notice sets up either the mechanics lien claim or the stop notice claim, depending on which remedy is appropriate to the occasion. The second step is essentially the same. Just as you have to record a mechanics lien within 90 days of completion of the project, likewise you have to serve a stop notice within 90 days of completion of the project. Step 3 is essentially the same. It's filing a lawsuit. In the case of a mechanics lien, the lawsuit is to foreclose against the property. In the case of a stop payment notice claim, the target there is the money. If there's an identifiable fund of money being used to finance the project, that's the target for the stop notice claim. And then the final step, step 4, is to collect. In the case of a mechanics lien, the sheriff's sale of the property and distribution of proceeds of the sale. In the case of a stop notice, the money that has been set aside by whoever's holding the money, whether it's the owner himself or a construction lender. So the procedure is the same, essentially, for mechanics lien and stop notice, but the targets are different. Again, the target of the mechanics lien is the property. The target of the stop notice is the money. Next sentence here on page 20 reads, "A stop payment notice may be used on both private works or public works projects. If you qualify, you may file both." Well, how does one qualify? To be qualified to pursue a stop payment notice remedy, you have to be a subcontractor or a supplier. Simple as that. The California legislature specifically designed the stop payment notice remedy to favor subcontractors and suppliers. I suppose the thinking back in 1969 was that general contractors have disproportionately large amount of bargaining power in the construction industry compared to subs and suppliers, and so the California legislature invented that new remedy for subs and suppliers. Farther on down page 20, under how it works, the first sentence needs to be highlighted. It reads, "The purpose of the stop payment notice is to require the property owner, lender, or public agency to set aside money to pay a judgment if the claimant wins a lawsuit in court to enforce the stop payment notice." Well, I've just explained that to you, I hope in sufficient detail. We're over onto page 21. At the top of the page, just to clarify the point, drive it home, mechanics lien is a hold on the title to property. Stop payment notice is a hold on funds committed to a construction project. Moving over to page 24, we've already discussed who may file a stop payment notice. That would be a subcontractor or material supplier. And in the case of a direct contractor, he could file a stop payment notice against a construction lender if there is one. Notification on private works, the idea is to serve or deliver the stop payment notice to whoever controls the flow of money. That's usually either the lender, if there is one, or the owner, if the owner is financing his own project. On public works, the stop payment notice is served on the public agency responsible for the work In the case of the state of California, you'd serve it on the head of the department responsible for the construction project. If we're talking about public work on a county or city project, then service would be on the controller or the auditor or disbursing officer or other responsible party for the agency that signed the contract. Let's turn now to page 25. At the top of page 25, you have a very useful diagram illustrating the flow of the notice and the money. The sub or supplier who's not getting paid like he's supposed to serves the stop payment notice on the owner or the lender if there is one, and then the owner or lender in turn, upon receiving the stop notice, has no choice but to set aside the money that the sub or supplier is claiming from out of the construction funds. And that money will sit there with the claimant sub's or supplier's name on it until the sub or supplier gets a chance to go to court and persuade a judge that he is indeed entitled to that money. If the sub or supplier is successful in court, he wins his judgment, he's not going to have to worry about how to collect on that judgment because the money is going to be sitting there waiting for him by virtue of the stop payment notice. Now, if the stop payment notice is served on an institutional lender, like a bank or a savings and loan association or a credit union, why then the lender has the right to require that the stop notice have attached to it a bond in favor of or for the protection of the lender. It may turn out that the stop payment notice claimant doesn't make his case in court. His lawsuit fails. In that event, the lender will have been put to a lot of trouble and expense for nothing. He will have had to probably interplead the money into court. He will have had to hire a lawyer, respond to pleadings, participate in discovery. All that costs money, and the lender ought not to be put to that trouble and expense if it turns out that the subcontractor's stop notice claim was a bad one. In that event, the lender can turn to the bonding company and say, well, your principal, the subcontractor, made a bad claim, and as a result cost us a lot of litigation fees, and we'd like to be reimbursed, please. And then the bonding company will turn around to the unsuccessful subcontractor and say, hey, your bad claim cost us a lot of money. You have to reimburse us now. So the stop notice claimant who's presenting his stop notice to an institutional lender had better hope he's right in making his claim, because if he's wrong, it could cost him a lot of money. The bond, by the way, has to be for 125% of the amount of the claim. So if the claim is for $20,000, the bond has to be for $25,000. We're on page 27 now, headed Payment Bonds. You want to highlight the first sentence of that section. It reads, the main purpose of a payment bond is to make sure there is a way of paying subs and suppliers in the event that the direct contractor fails to do so. Moving down to the next paragraph, you'll want to highlight the first sentence reading, when a contractor provides a payment bond for a home improvement project, the contract does not need to include a payment schedule or a mechanic's lien warning. And the contractor may also accept a larger down payment than the usual $1,000 or 10% of the contract price, whichever is less. The reason for that is, of course, that the payment bond stands ready to pay the subs and suppliers if the general contractor fails to pay them, and the owner is thus protected from the possibility of losing his property to a mechanic's lien claim by a sub or supplier. Moving over now to page 29, summary of bonds associated with stop payment notice. You've got three different bonds identified there. The first one is a stop payment notice bond. This is a bond served by subcontractor claimant along with the stop payment notice. The idea is that the bond will stand ready to provide security for damages to the owner, the lender, the direct contractor, in case the stop payment notice proves to be invalid. In other words, if it turns out that the subcontractor's stop payment notice claim fails because it's not meritorious or because it's procedurally flawed, whatever the reason, the bonding company will pay off the lender and the owner for their expenses that they unnecessarily had to incur on account of the subcontractor's lawsuit. The next bond described here is a release bond. It's a bond posted by a direct contractor or the owner who disputes its stop payment notice. Again, the idea is to free up the money for the project so that the owner and the direct contractor can continue with the project fully funded. The bond is substituted for the money as the target of the stop notice claim. And then finally we have the payment bond. This is a bond posted by the direct contractor providing security for subs and suppliers in case the direct contractor fails to pay them for some reason. Let's move on now to the next page, 30, owner's rights. The owner of the property is afforded a few protections in order to avoid unfair advantages to him. The first is a notice of non-responsibility. This contemplates a situation where a tenant, not the owner of the property, but a renter of the property, hires a contractor to do some improvements. Normally, as we've noted, a contractor has the right to make a claim against the property itself by means of the mechanic's lien if he doesn't get paid for his labor and materials. Well, in the case of a renter or tenant hiring the contractor, the owner, of course, is not going to want to let his property be on the hook for a debt that the tenant has racked up, a debt that the tenant has incurred. So in that case, the law allows the owner to record and post on the property something called a notice of non-responsibility. It's simply a statement by the owner that he's not going to be responsible to the contractor for the project the contractor is constructing on the owner's property if the tenant fails to pay the contractor. That means the contractor can only look to the tenant to get paid. He cannot look to the property. And then we have a notice of completion. You want to highlight the first paragraph there under the heading Notice of Completion, Notice of Cessation. A notice of completion, an example of which you have on page 32, is a declaration by the owner or the owner's agent that work on the project is finished. It must be in writing and verified by the owner or the owner's agent, usually the general contractor or the architect. And if a notice of completion is recorded within 15 days after completion of the work, that shortens the time that general contractor, subcontractor, material suppliers have to record their respective liens or serve their stop notices. Over on page 31, at the top of the page, we have some important deadlines for you to bear in mind. We mentioned notice of completion being an official declaration that work on the project is finished. When that notice of completion gets recorded, that sets the time running for the general and the subs and suppliers to record their respective mechanics lien claims if ever they're going to. From the date the notice of completion is recorded, the general contractor has 60 days from that date to record his mechanics lien or forever forego the lien right. And the subs and suppliers only have 30 days from the date the notice of completion is recorded if ever they're going to exercise their mechanics lien rights. If no notice of completion is recorded, then everybody, general, sub, suppliers, everybody has 90 days after actual completion of the project within which to record the mechanic's lien. It's a little complicated, I admit, but it's simplified here by this drawing on this diagram on page 31, a very useful diagram, that 30, 60, 90 degree triangle. This is an easy way to remember this otherwise rather complicated rule. Again, the rule being that if the owner or his agent has recorded a notice of completion, then that means that the general only has 60 days after the notice of completion is recorded, and the subs and suppliers only have 30 days from the date the notice of completion is recorded within which to record their respective mechanics liens. Otherwise, they're closed out. They're time barred from recording their liens. If the owner has not recorded a notice of completion within 15 days of completion of the project, why then everybody, general, sub, suppliers, they all have a full 90 days after actual completion to record their mechanics liens. Now the diagram on page 31 is pretty simple, really. The two angles at the top of the triangle and at the right side of the triangle, those two angles are touched by that long line there called the hypotenuse. Fancy Greek word. It refers to the longest line of the triangle between the 60 degree angle and the 30 degree angle. Okay. Since those two angles touched by the notice of completion show 30 degrees equivalent to 30 days, that's how much time the subcontractors have to record their liens. And the 60 degree angle shows 60 days, and that's how much time the original contractor has, the general contractor has, to record his lien. And in the right angle corner there, the lower left side of the triangle, that angle is not touched by the notice of completion, you'll notice. And therefore, it bears 90 days for all the claimants. You want to highlight the first sentence under the diagram, which reads, everybody has 90 days if no notice of completion or cessation is filed. If such a notice is filed, the deadline is shortened to 30 or 60 days, as I've just explained. Now, what determines the date of completion for mechanics lien purposes? The law will look successively to three possibilities. The first possibility is the owner expressly states the job is completed. He'll say, fellas, thanks a lot, you did a great job, you can pick up your tools and go home, the checks are in the mail. Usually the owner is not that obliging. So the law looks to a second possibility to determine the date of completion. And that possibility is a date when work stopped, no more work going on, and the owner takes possession of the property. Like two rivers flowing together into one, those two events have to happen simultaneously. That is to say, no work going on, cessation of labor, and the owner taking possession. When those two things, the moment those two things happen together, that date marks completion. And finally, if all else fails, then the law will look for 60 straight days of cessation of labor, nothing going on the job site. After the 60th day of nothing going on, the law will start counting down the deadline. 90 days, all the contractors and subcontractors have 90 days after the 60th day of nothing going on within which to record their mechanics liens. How do you know if a notice of completion has been filed? Well, one way is to take a look at, go down to the county recorder's office and take a look and see whether or not notice of completion has been filed. Another thing you can do is simply record your mechanics lien if you need to within 30 days after completion of the project, and you're good. You're on time. No matter what the owner is doing, he cannot say that your mechanics lien is time barred. Toward the bottom of page 33, we have the heading Waiver and Release. You should highlight the first sentence there. It reads, when construction bills are paid, the owner, lender, or direct contractor may require a sub or supplier to sign a waiver and release of rights to a lien, stop payment notice, or payment bond. Yes, you'll find that as you progress through a project, if you're general contractor or subcontractor, you'll probably be called upon to release partially your right to a mechanic's lien, proportional to how much you've done relative to the total amount of the work to be done. On the top of page 34, you've got 4 types of waiver and release. These are all statutorily prescribed. The first one is a conditional waiver and release upon a progress payment. Conditional waiver and release means that you're releasing your lien rights and your rights to a stop payment conditionally upon the check you're being paid clearing the bank. In other words, the waiver and release you're giving is conditioned upon your being paid a negotiable check. The waiver and release doesn't count if the check bounces. Unconditional waiver and release, that's the second waiver described here. Unconditional waiver and release upon progress payment means that you're accepting the check as good. You're taking the risk that it'll turn out not to be good. And frankly, as a construction lawyer, I don't like unconditional waivers. I want that check to clear first. The third waiver described here is conditional waiver upon final payment. At the end of the job, you're expecting to be paid your last payment. The owner may ask you to sign an unconditional waiver and release, meaning that you're accepting that final check as good payment, whether it's honored by the bank or not. Your best bet is to sign a conditional waiver and release, meaning that you'll accept the final check, but if it bounces, then you're not giving up your final rights to a mechanic's lien claim. So the conditional waivers are the safer ones for the contractor to sign. If you have any doubts about signing a waiver and release, the best thing for you to do is consult with a lawyer. Get the lawyer to look things over and give you a professional opinion about just what you should do. Usually, when there's going to be trouble over money, it occurs toward the end of the job. When the final payments are due, the owner doesn't need the contractor's services that much anymore. That's usually when disputes arise. So know your rights and protect them by using the proper waiver and release form. The heading lien release at the bottom of page 34 reads, if a contractor files a mechanic's lien but afterward is paid, the owner will undoubtedly ask for a written release of lien, as I just described. The contractor is required to record the release of lien, but it's usually the owner that does the recording because it's the owner who wants to protect his property. We're on page 36 now with the heading lawsuits. And as I explained earlier, the lawsuit is the third step in the process of perfecting a mechanic's lien claim. The first step, as you recall, was serving the preliminary notice. That's something that subs and suppliers have to do. The second step is to record the mechanic's lien. And this third step is bringing the lawsuit to foreclose on the mechanic's lien. At this point in the process, you'll probably need a lawyer. It may be enough for you to send the owner a complimentary copy of the mechanic's lien that you're going to be filing that might move the owner to take a serious interest in your claim, perhaps get you paid off to preclude the need for anybody going to court. But that doesn't always happen. Sometimes the owner does not see the light or feel the heat, as the case may be. And so you have to go to the third step, filing a lawsuit. The mechanic's lien will expire 30 days after being recorded if you don't file a lawsuit in the meantime. So if you miss the 90-day deadline for filing the lawsuit, again, the mechanic's lien goes kaput. It's like dropping that crystal vase. Once it's shattered, you can't put it together again. There is a provision in the law for the 90-day limit to be extended if the owner and the contractor claimant agree to an extension of time. It's called a credit. It's got nothing to do with credit of money. It's a credit of time. The owner and the contractor can agree to successive 90-day extensions of time, which will give them time to negotiate. That way, the owner doesn't have to respond to a mechanics lien foreclosure suit, and the contractor doesn't have to file a mechanics lien foreclosure suit, giving them both more time to negotiate their differences. There's a sentence here at the end of the second paragraph on page 36. It reads, "The lien foreclosure lawsuit must be brought to trial within 2 years of filing the lien unless the judge in his discretion extends the time." So if you do have to file a lawsuit, be sure that your lawyer acts diligently to prosecute the lawsuit. Also to be highlighted is the sentence toward the bottom of page 36 reading, "You must also record a lis pendens notice within 20 days after filing a lien foreclosure lawsuit." Lis pendens is a Latin phrase meaning dispute pending or lawsuit pending. The lis pendens notice is a warning to subsequent would-be purchasers or claimants against the property that a lawsuit is being filed against the property, and that if they do take title or take an encumbrance against the property while the lawsuit is pending, they take subject to the outcome of that lawsuit. The practical effect is nobody's going to want to buy a piece of property with a lis pendens recorded against it, because nobody knows what the outcome of that lawsuit is going to be. Over on page 37, at the top of page 37, it reads that a mechanics lien is a powerful action. It takes precedence over most binding legal actions. I just told you that. The thing to remember is that first in time is first in right at the recorder's office. When you record your mechanics lien, anybody else with a claim against that property has to get behind you in line if the other guy came in later than you did with his claim. And it bears mentioning also that the mechanics lien is effective when the contractor visibly starts work on the property. Even if the contractor records a mechanics lien later than, say, a lender records a deed of trust, if the contractor started his work before that deed of trust got recorded, his mechanics lien is effective from the date he started work, even though he recorded it after the deed of trust was recorded. That's because once the contractor starts work, visibly starts repairing, remodeling, whatever he's doing, anybody interested in that property can see visibly that the contractor is working on the property, and that therefore an eventual mechanics lien claim is a possibility. Stop payment notice lawsuit. Lawsuit to perfect a stop payment notice may be filed no later than 90 days after the period for recording liens. Notice of the lawsuit has to be given to the person or public agency who's been served with a stop payment notice, and that notice of the lawsuit has to be served within 5 days after filing the lawsuit. So your lawyer won't have much time between the time he files the lawsuit to perfect the stop payment notice and the time he has to serve that lawsuit on the person or public agency who's being sued. Payment of labor and materials bond lawsuit. The lawsuit to enforce a claim on a private works payment bond is filed against the bonding company. And if the bond was recorded, the bond lawsuit has to be filed within 6 months after completion of the work. If the bond was not recorded, the time limit is 4 years. Over on page 38, lawsuit against a public works bond. This lawsuit is to enforce a claim on a public works payment bond. It's filed against the bonding company. Again, this type of lawsuit may be filed whether or not a stop payment notice has been filed. It must be filed within 6 months of the deadline for a stop payment notice. So again, lawsuit against a public works bond has to be filed within 6 months of the deadline for a stop payment notice. Finally, collection procedures. Once you and your lawyer have teamed up to win a glorious victory in court, and you go dancing out of the courthouse, singing a happy tune, with a judgment in your favor in hand, it's time now for you to enjoy the glory, the majesty of the mechanic's lien. And that is, you don't have to worry about how to collect on the judgment. All you have to do is go to the sheriff's office, fill out a form called a writ of execution, and the sheriff will take it from there. He will pick a date and a time and a place for the upcoming foreclosure sale, and pursuant to the judge's order, the sheriff will auction off the property to the highest bidder. He will collect the money from the highest bidder within 10 days. It has to be all cash, paid within 10 days of the auction. And out of the proceeds of that sale, the sheriff will pay off the mechanic's lien claimant. And that is the four-step process, completion of the four-step process of the mechanic's lien procedure. Now, on pages 40, 41, and 42 of your book, you have a very useful summary of mechanic's lien law. You've got your documents described here, the purpose of those documents, when they have to be filed, posted, or recorded, and with whom. Very, very useful information. And I'm sure that this three-page summary will come in very handy many times. And all of you, I wish you the best of luck in your construction careers.
Hi guys, my name is Pat Crowell. I'm an attorney here in Sacramento, California. I am a founder and trial attorney of Crowell Law, where we specialize in plaintiff employment law. So cases like retaliation, discrimination in the workplace. Let's get started on chapter 4 of your course, entitled Employment Law. Now we're at the top of page 1. It's titled Job Ads, Applications, and Interviews. Now when you go to hire employees, you're going to post your job somewhere. Your job posting has to be accurate. You can't make any misrepresentations in your job posting. Your type of work has to be accurate. The length of time the job will last. The wages and benefits that you offer have to be accurate. And I'm only going to highlight what the most important parts of this section are. So if you want to follow along with me and highlight the portions that I talk about, that'll be a lot more beneficial for you. Now, a standard job application includes information about previous employers, work experience, availability, and education or training. Opinions about prospective employees' honesty or integrity must be obtained by contacting the individuals listed as references. Now, there's some things you cannot ask during the interview. Those things are the age of the job applicant, his national origin, his sex or sexual orientation or marital status, what his religion is, if he's had an arrest record, unless there's a conviction based on that arrest. So that is fine. You also cannot ask someone about their disabilities during the hiring process. In some instances, you may require the applicant to perform a skills test to determine that they have the necessary knowledge and skills to perform the job. But that test has to actually correlate to what they'll be doing in the job site. So you can't ask someone to do 100 jumping jacks unless that's something actually you think is required in the job. It's just another way to combat any kind of discrimination in the hiring process. Let's turn to page 2. The top of the page talks about hiring and firing minors. So in your book, if you want to highlight the section where it says minors, You may choose not to hire employees if they're under 18 years old. So this is the only time where you actually can discriminate based on age. So if someone's under the age of 18 years old, you don't have to hire them just strictly because of their age. Now moving down to the section of polygraph tests, photographs, and physicals. And down the third paragraph states if an employer requires a medical or physical examination as a condition of employment, it is the responsibility of the employer to pay for it. So that means if you are going to have all these individuals that are trying to get a job with you, if you want to put them through any kind of exam, medical, physical, or any kind of drug testing, it's on you to pay for it. So you want to highlight that in your book. Now moving down to the section Form I-9, which is the employment verification eligibility. If you go to the second paragraph there, you want to highlight the portion where it says employees must complete Section 1 of the Form I-9 no later than their first day of employment. So this is this form that states that they have a right to work in the United States, and they have to have that thing filled out their first day on the job. And the last sentence on page 2 is really important. It states, within 3 days of starting to work for pay, employees must present documentation to their employers that establishes their identity and employment authorization. Now turning to page 3, this is the I-9 form that we talked about. This is the form that you will get. You can actually just Google these forms and you will give these to your employees and have them fill these out, like I said, on the first day of the job. So take a chance to review these and look at what's on them. On page 4, it's just the second half of that I-9 form. Moving on to page 5. On the top of page 5, you'll want to highlight just the first section, the first sentence up there. It states employers must complete Section 2 within 3 business days of the employee's first day of employment. So if you go back and look at page 4, that's the Section 2 of that I-9, so that's the second half of it. You have to fill this out within 3 days of getting a new employee, of 3 days of him working on the job. Now if you go down to the middle section of page 5, we put in these practice questions. And these are just kind of to test your knowledge. And I may not go through each of them, but they're there for you to go through. Kind of gives you more of a highlight of what the test is going to be on. So I recommend that you go through each of these. So let's just go through the first one right now. It states, when may an employer ask an applicant about what holidays the applicant observes? So if you remember back to when we talked about the questions that you can ask an applicant, so someone that's interviewing for your company, and we talked about you can ask about someone's religion. So, and typically certain holidays or certain religions have certain holidays. So, and the question here, when may you ask an employer, or when may an employer ask an applicant about what holidays the applicant observes? It's never, because that would trigger what kind of religion that person, follows. So your answer number 1 is never. So I'll move on to page 6. This is our section on human resources. Now our first topic is personnel files. This is typically a file that's held if you have a human resources office, or you if you're just the only manager or owner that you'll be maintaining on all your employees. It's going to consist of their application, their W-4, what we're going to talk about later. It's a tax form that they will fill out, that I-9, any emergency contact forms, performance reviews, and attendance records, and really anything else you want to include in their personnel file. But those are kind of a guideline of things you want to include in a file for each of your employees. Now if you move down to the second paragraph from the bottom, you want to highlight this paragraph. It states, employees have the right to review their own personnel file and any records that the employer keeps regarding the employee's performance or any grievance concerning the employee. So that means if you're keeping records on employees, they get the right to look at those, no matter what it is. If you're keeping records on, like I said, their performance or any kind of discipline on those employees, they also have a right to review them. You can't just keep them secret from the employees. Moving on to the last paragraph on page 6. Employee file should be kept in a locked cabinet or room. Now this is just kind of common sense. These are going to be really important documents you're going to have on all these employees, and hopefully you have a lot of employees, but you need to keep these things separate and away from anyone else that could see them. Some things are going to be personal. I'll move on to page 7. Your first topic here is employee handbooks. Now, I strongly encourage you to have an employee handbook. Your employee handbook would include company policies, your anti-discrimination policies. So your company doesn't discriminate against anyone because of race, gender, age, religion, all those things we talked about in the hiring process. And just the compensation, the general employment information, your working hours, standard of conduct, employee benefits, so any kind of 401k or vacation or those things, your leave policies, that could be medical leave, bereavement, if someone passes away in the family, and also your policies on safety and security. And moving on, now we're at the bottom of the page under performance reviews. Now if you go to the second paragraph under performance reviews, the section where it says, well before undergoing a performance review, preferably at the time of hiring, employees should be given a detailed job description. Now a job description just outlines exactly what you expect that employee or that group of employees in that certain specification to do every day. You want it to be very detailed and actually include the things that they actually do. And you don't have to have specific ones tailored for each employee, but if you have 10 laborers or 10 concrete guys, 20 truck drivers, you can put them, lump it in to just have one for each type of job. But this will help them know what is expected of them in terms of job duties. And it'll provide a basis for you to evaluate them and their performance. If we want to move on to page 8, the top of the page, we cover sexual harassment. Now, if you need to highlight the section under sexual harassment where it states employers must provide information on the nature, illegality, and legal remedies that apply to sexual harassment. So this means you have to somehow post in the job site or in the break room what sexual harassment is and that it's prohibited in the workplace. Now, sexual harassment's like profanity or saying things about the females walking by, anything like that. You need to have a policy about it and have it posted in your workplace or anywhere for the employees to see. We'll move on to section under minors. So minors are your young kids, not guys out there in the caves or whatever, trying to get gold and that stuff. So we're talking about people under 18 years old, so kids trying to work for you. So you want to highlight the first sentence under the minors section where it says, it is a misdemeanor for an employer to hire or allow any person under the age of 16 years to work in any of the following capacities. So you can't hire anyone under the age of 16 in any of those bulleted jobs. So the ones you want to highlight are you can't hire anyone under age 16 to drive a car, any kind of car, truck, big rig, a small car, a Prius, doesn't matter. You can't hire anyone under 16 years old to drive any kind of car. And also, you can't hire anyone under the age of 16 to work on scaffolding or, heavy work in the buildings trades and any tunnel or excavations or in or around mines or quarries. So the two main areas where you want to focus on and what you cannot hire a minor to do, so a child to do, 16 years or younger, is to drive a car or work on scaffolding or heavy machinery and work in the building trades. If we'll move on to page 9. On the bottom of the page, we provide the information on the professional strike breakers. So this is on the bottom of your page. This states it is illegal for an employer to hire professional strike breakers as replacements for employees involved in a strike or lockout. A professional strike breaker is a person who has replaced striking or locked out employees of 2 or more separate employers in the last 3 times in the past 5 years. So you cannot hire these people that have worked as strike breakers in other jobs twice in the last 5 years. So you need to be aware of that if there's ever a strike in your company. We'll move on to page 10. On top of page 10, we provide information on the right to collective bargaining, and this is what we call unionizing, so unions. The National Labor Relations Act of 1935 established the rights of workers to organize into unions and to negotiate contracts. You want to move down to the second paragraph. Collective bargaining agreements negotiated by employers and unions often contain a successor clause. That means anyone who succeeds, so anyone who buys the company from somebody else, the employer is bound by that previous agreement until that expires. So if you go in, you're doing well in your company, and you go and buy another company, and that other company had a union agreement with those employees, you're on the hook to abide by all those contracts and regulations in that previous union agreement until it expires. But as this reads on, Labor Code Section 1127 limits a successor clause for collective bargaining agreements to 3 years. So say you buy a new company, they have a union agreement they've entered into that lasts for another 10 years. You're only on the hook for the 3 years. So that's Labor Code Section 1127. And then moving on to page 11, payroll. So on this section, on the first section, time cards / records, you need to highlight just that first sentence where it says, employee time cards should be completed daily. So every day, either you, the employee, or another timekeeper at the company has to complete the employee time cards every day. It's very important. Now, a typical time card includes the employee's name, the pay period, a job, project number, but more importantly, includes the days and hours the employee worked and description of the work. So if you move down to the second paragraph, it states on the last sentence, payroll records must be kept for at least 3 years. So this means that even if an employee worked for you for a week 2 years ago, you still need to keep their time records. Now, it's another thing, you should probably keep those in a safe place, away from any other people coming in out of the office or anything like that. Now, turning to page 12, wages. So, wages must be paid twice a month on days designated in advance by you, the employer, as the regular pay days. So you can't have jumbled up different pay days that you're paying these guys. It needs to be set in advance and it needs to happen twice a month. So some examples are, every 2 weeks or twice a month. So that could be the 1st and the 15th those are some guidelines. On the second paragraph, employees who are terminated must be paid immediately. If an employee quits without notice, wages must be paid within 72 hours. So this means if an employee just stops showing up, maybe he tells you he quits, but he says, I'm quitting right now, calls in, you've got to get him his paycheck within 72 hours of him letting you know that he's no longer working for you anymore. And also if you fire an employee, you have to pay them right away. Now let's move to the third paragraph on page 12. The employer may deduct for lost time if an employee is late for work. So if an employee is late for work, you can deduct his time. But you cannot deduct more time than he would have earned had the employee arrived on time. So you can't deduct an employee 2 hours if he was only 1 hour late to work. However, there is one exception to this rule, and this is in paragraph 3. On the second line to the right, it starts out, however, Labor Code section 2928 allows the employer to deduct a half hour's wage for any time lost during the first 30 minutes of a workday. So if an employee shows up 15 minutes late, you can actually deduct them the full 30 minutes. But that's the only time you can deduct an employee more time than they actually missed. So it's kind of tricky. So just kind of think about that one. And under this Labor Code section 2928. So that might be a friendly Labor Code section for you. Now let's move down to paragraph 4. A wage deduction statement is a document that lists the deductions from an employee's wages. So these are things like taxes, retirement contributions, Social Security, things like that. You need to provide an employee with this statement. You'll need to highlight the last sentence on this paragraph that states, the statement may be a detachable part of the paycheck or a separate itemized form if wages are paid in cash. So the way to think about this statement that you give them about any kind of deductions, so any money that they're not getting, you need to provide them with some kind of physical piece of paper that states where that other money went. So it can be attached to their check or just a piece of paper with the cash if you're paying by cash. So turning to page 13, let's go to the middle of the page under overtime. 8 hours of labor is 1 day's work. Unless an alternative work week schedule is adopted, allowing employees to work longer hours, any work beyond 8 hours in one work day or 40 hours in one work week is considered overtime and is paid at the rate of 1.5 times the regular rate of pay. And any work beyond 12 hours in one work day is paid at twice the regular rate of pay. So what this means is if you have any employees that work over 8 hours one day and you haven't given them this alternative work schedule, which would be if you have an agreement that the employee is going to work 3 12-hour days each week or 4 10-hour days in each week. If you don't have anything set up like that, then anything over the 8 hours is considered overtime, and you have to pay them time and a half for those hours in between 8 and 12 hours. Now, if it gets over the 12 hours, then you have to pay them twice their regular rate. Let's move to page 14 and under wage garnishments. So if you go down to the bottom 2 paragraphs, if an employee's wages are garnished and the labor contract provides less protection than the state's guidelines, the provision of the labor contract that provides the employee with the less protection is considered to be against public policy and is void. But it does not void the entire contract. So This means that if you have an employee whose wages are being garnished and there's two different conflicting protections for that employee, whichever one protects the employee the most is the one that you have to follow. And the other one is considered against public policy. Under the last paragraph, under wage garnishments on the bottom of the page, states, if an employee is fired due to a wage garnishment, the employee must give notice to the employer within 30 days of their intention to file a wage claim. The employee has 60 days to file the actual claim with the labor commissioner. So if you fire an employee because of his wage garnishments, they have 30 days to give you notice. So to let you know, hey, I'm going to file a wage claim. And then they have another 30 days, or a total of 60 days to file the actual claim with the labor commissioner. Turn over to page 15, and let's go to the section child support. And under Amount 1, you need to highlight the Amount 1 section under child support. Now, Amount 1 states 50% of employees' disposable earnings if they are supporting a spouse or child not subject to the order. So if you have an employee who has to pay child support, but he also has a spouse and another child, but is not subject to that child support that he's paying, you pay 50% of the employee's disposable earnings as child support. Now let's turn to page 17. This section is titled Employment Taxes. Go to the section titled W2. So it's actually W-2, but everyone calls them W2s. The W2 is a form that lists an employee's personal information along with wages for the year and tax withholdings. Now let's turn over to page 18. Employers with one or more employees must generate W-2 forms and file them every year. W-2s must be given to employees and submitted to the Social Security Administration by January 31. You must also keep a copy on file with payroll tax records. The IRS requires that all tax records must be kept for a minimum of 4 years. So here, it's 4 years. Remember, our payroll records were 3. So your tax records are for each employee is 4 years. So remember, there's a difference between payroll records and tax records. So you got 3 for payroll and 4 for tax records. Now, if you go down to the middle of the page, you have your W-4 forms, and this is a form that your employees will fill out when they start to work. Let's move on to the last paragraph. If an employee does not turn in a signed W-4, you, the employer, should withhold income tax as if the employee were single with no withholding allowances. An employee will be required to complete a new W-4 after a change in marital status or if the employee has a change in the number of withholding allowances. Turn to page 19, on the top of page 19. The employee's signed W-4 should be kept with the rest of the payroll records for a minimum of 4 years. So you have to keep their signed W-4 for a minimum of 4 years. Now let's move down page 19 to the section titled Independent Contractor versus Employee. As a general rule, a worker is regarded as an independent contractor if an employer has a right to control or direct only the result of the work and not the means and methods of accomplishing the result. If an employer has a right to control what will be done and how it will be done, the worker is considered an employee. Now, if you go down to the middle of the page, under the other standards that are used to determine whether a worker is an independent contractor or an employee, we provided you with 4 bullet points that you can use as factors in determining whether an employee or whether a person is an employee or independent contractor. You want to highlight the third one. It states the extent to which the worker can realize profit or loss. Independent contractors may earn a profit or loss. So you need to know that. Move farther down 19. The last paragraph under independent contractor versus employee. This starts out with any worker who is hired as an independent contractor rather than an employee must be given a 1099 form by January 31. Now again, if this date is different than what's in your book, go by the date that's provided in your book. You have to provide a 1099 if that person was paid more than $600 over the course of the year. Payroll taxes are not required to be withheld from independent contractors. You're not required to issue a 1099 to most corporations. And it's moved down to federal payroll taxes. An employer who has one or more employees, whether temporary, part-time, or full-time, must obtain an employer identification number from the IRS. So if you have 1 or 1,000 employees or even more, whether or not they're temporary, part-time, or full-time, you have to go to the IRS and get an employer identification number. This number is used to identify the employer's tax account and should be used on all forms submitted to the IRS or the Social Security Administration. So let's move over to page 20. The first section is titled Federal Income Taxes, which is FIT for short. It states each employer must withhold federal income taxes from the wages of all employees not claiming exemption. So if you have any employees that do not have an exemption from federal income taxes, you as the employer must withhold that taxes from them. FIT is withheld from all wages, tips, and other compensation such as bonuses earned by the employee. Only the employee pays federal income tax, and there is no wage-based limit. But you as the employer must be the one to actually withhold that tax from the employee's wages. The employee does not do that, so you have to. Let's move down to the next section, Federal Insurance Contributions Act, which is called FICA. The employer must also withhold the FICA taxes from the wages of an employee. FICA taxes are Social Security tax and Medicare tax. So if you've seen your own paychecks, you've seen FICA on there before, and now that you're going to be a business owner, you have to be the one to withhold those taxes, just like the federal income taxes. These taxes are paid to the IRS by both the employer and the employee. In other words, the employer must contribute to the IRS the same amount withheld from the employee's wages. So here, both you and your employee are contributing to FICA. So you both have to contribute, but you're the one that withholds the taxes. Now let's move down to the section called FIT and FICA filing requirements. It states, most employers must report FICA taxes and any FIT withheld from employees' wages to the IRS on the basis of a calendar quarter. So, if you do have employees who are not claiming exemption, you'll be taking FICA taxes and FIT taxes. So you have to provide the information to the IRS on the basis of a calendar quarter. Now you'll have a table in your book with these filing deadlines for this Form 941. Now if you move To the bottom below that table, you want to highlight that first sentence that states, if FICA and FIT taxes are $2,500 more per quarter, employers will have to make deposits before the Form 941 quarterly return is due. So you have to make deposits before that Form 941 is actually due. So you need to remember that. Now let's turn to page 21. The first section is individual and self-employment tax. Payroll taxes should not be confused with contractors' personal income tax. So you have the tax that you pay for your employees and that they pay, and that's different than your own personal income tax. A contractor is still responsible for filing his own personal income tax return with the IRS using a Form 1040, and also with the California Franchise Tax Board using a Form 542. Let's move down. For self-employed contractors, FICA taxes are paid as self-employment tax. You must pay self-employment tax if you had net earnings of $400 or more as a self-employed person. So if you are self-employed, you have to pay taxes for yourself as an employee and also as a self-employed business owner. So you're going to be paying contributions for both as an employer and the employee. So we can move down to section titled Federal Unemployment Tax Act, the FUTA. Every employer has to pay federal unemployment tax. I need to highlight the last sentence of that paragraph that states this tax must be paid by the employer and may not be deducted from the wages of the employee. So the employee does not pay this unemployment tax. You, as the employer, pay the unemployment tax. Now let's move down to the state payroll taxes section. California EDD administers the following California payroll tax programs. The two most important ones that you guys need to know are state disability insurance and California personal income tax withholdings. So let's move on to page 22. If you had one employee work for you for one day and you paid him over $100 in any calendar quarter, you are considered an employer by the California Unemployment Insurance Code. So each employer is required to register with the Employment Development Department, and that's the EDD, and obtain a state employer identification number. Note, this is different than your federal employment identification number. So if you're considered an employer under the California Unemployment Insurance Code, you have to also go and get this state identification number as well as the federal employer identification number. Let's move down to the bottom of page 22. California personal income tax withholdings. States California personal income tax is a tax levied on the income of California residents and on income that California non-residents derive within California. So this is a tax for, you don't even have to actually live in California to have this tax put on you. It can be residents or the non-residents that get income from the state. Let's turn to page 23, and we've provided a table of when you have to provide this quarterly contribution return and wage report. Look to your book at this specific table for your filing deadlines. Now let's turn to page 24. This is a table that we've provided just to kind of make things easier on this tax section. This is a quick reference to who pays what taxes and what you have to do for these certain taxes. So if you're confused at all about any of the tax stuff I just went over, and I mean I would be too, you can look at this table on page 24. It's a really quick reference for you and it's really helpful. So please review page 24. Now let's turn to page 26. This is our section on workers' compensation, sometimes called workers' comp. The CSLB pays a lot of attention to the section on workers' comp. If you have one or more employees, you have to have workers' compensation. The purpose of workers' compensation is to limit you as the employer's liability, is to avoid costly lawsuits, and to guarantee that workers receive prompt and complete medical treatment and other benefits, which is wage loss, for job-related injuries. Now, let's go down to the section of the page that states, special note for roofers. This is very important as well. It states all active licensees holding the roofing C39 classification must have either a valid certification of workers' compensation insurance or a valid certification of self-insurance on file with the contractor's state license board, regardless of whether or not they have employees. Now let's turn to page 27. Let's go into the section titled Premiums. Premium is how much you as the employer pay for this workers' compensation insurance. Now, how much you pay is based upon how employees are classified by their work duties, as well as the rate assigned to each corresponding work classification. So, a company with employees that work in an office doesn't pay as high of a workers' compensation premium as a company with guys that work on the roof. They're going to have the guys that have people working on the roof are going to pay a higher premium for workers' compensation. That's kind of how the calculation is, how the calculation is come up with your premiums. Let's go down to the third paragraph under premiums and highlight that whole paragraph that states the final premium of a workers' compensation policy is calculated when the policy term is over and the employer's payroll records have been audited. The final audit of payroll records determines if the initial payroll estimate was either high or low. If the payroll has gone up from the estimate, then the employer will owe additional premium. If the payroll has gone down from the estimate, then the insurance company will owe the employer a return premium. So you won't really know what you're going to have to pay for this workers' compensation insurance until after that policy term is over. So you need to budget for that. So in that last sentence under premiums, it states deliberate underreporting of payroll is considered insurance fraud and can be prosecuted. So you cannot underreport your payroll. You can be prosecuted for that. So do not do that. So let's turn to page 28. Under the section who can receive workers' compensation benefits. It states, with a few exceptions, the workers' compensation law applies to all employees, including full and part-time employees. Now let's turn over to page 29 under the section notice to employees. So let's just walk through it. It states, employers must post conspicuously in a location frequented by employees a notice stating that the name of the employer's workers' compensation insurance company, or if the employer is self-insured. If the employer has purchased workers' compensation insurance, the notice must include the expiration date of the policy. Failure to keep this notice posted is a misdemeanor. So you have to provide this information in a place the employees are going to see it. So in the break room, if you're working on site in the construction trailer, places like that. So let's go down to the second paragraph that states the employer must give new employees, either at the time the employees are hired or by the end of their first pay period, written notice that they have the right to receive workers' compensation benefits if injured at any time while working for the employer. So if you get a new employee, you have to actually give them a notice that you have workers' compensation insurance, and that they can file a claim if they've been injured at any time while working for the employer. Now let's go down to the section titled Penalties. Go down to the fourth paragraph. This section states if an employer fails to provide workers' compensation or allows a policy to lapse and an employee is injured, the injured employee has the right to sue the contractor in civil court. So if you don't have a workers' compensation insurance, or you let your old workers' compensation insurance lapse, the employee that gets hurt on the job can sue you in civil court. So you need to make sure that your policies are up to date. Let's move down to the last section on page 29. Highlight this section. There's 2 sentences. States, the employer is responsible for paying workers' compensation insurance premiums. It is a misdemeanor for an employer to deduct the premiums from the wages of the employees. So number 1, you as the employer have to pay the workers' compensation insurance premiums. Number 2, you cannot deduct that workers' compensation premiums from your employees. You have to pay it. Turn the page to page 30. Under reporting requirements, within 90 days after you purchase a workers' compensation policy, you must report the insurance company's name and address to the registrar of contractors. Now let's move to the bottom of page 30. Cities and counties requiring the issuance of construction permits must also require that applicants sign a workers' compensation declaration to verify workers' compensation coverage or exemption from coverage. Now if you turn to page 31, here is an example of that workers' compensation declaration. Now you will need this when you're going to pull a permit for a job. And this is not the exact one that it's used by every county, so these workers' compensation declaration pages could be different in your specific county. But this is just a good example for you to look at and familiarize yourself with. Let's turn to page 33. This section is called Safety in Employment. If you go down to the third paragraph of the page here on 33, the Cal OSHA program is approved, monitored, and partially funded by the Fed OSHA program. It consists of 4 independent cooperating units. And you want to highlight the 4th cooperating unit, which is the Cal OSHA Consultation Service. The Cal OSHA Consultation Service helps employers and workers solve safety and health problems without fear of citation or penalty. And just a note on the Cal OSHA, the consultation service. They will actually come out to your job site and review and make sure you're within compliance with all the health and safety regulations. So it's a very good resource to have. So let's turn to page 34. Go to the section in the middle of the page that says Contractor Employer Obligations. Now go down to the section that says a contractor who is an employer is required to. So we provided 6 or 7 bullet points of what you as a contractor, as an employer, is required to do under the labor code. You need to maintain a place of employment that is safe and healthful for workers. You need to know and comply with safety and health standards, provide an effective written injury and illness prevention program that includes training of workers on hazards and safe work practices on their specific work assignments. I go down to the second to last bullet point. You need to highlight that section. It says post any citation for safety and health violations near the place of violation for at least 3 days or until the violation is corrected. So if for some reason you get a citation from Cal OSHA, you have to post that citation at or near the place of the violation. So that way that other employees know that that's there and can kind of avoid it if it's still going on, or you can take that citation down 3 days after the violation has been corrected. So let's turn to page 35. Top of the page, we have another bullet point. It's another requirement under Cal OSHA that you obtain a DOSH permit for, and then we have four examples of why you have to obtain a DOSH permit. The one you want to highlight is the first one. You need to obtain a DOSH permit for construction of trenches or excavations 5 feet or deeper that workers must enter. So if you're working where you're going to be working on trenches or excavations 5 feet or deeper that you're going to have your employees go into, you have to go and get a DOSH permit. So highlight that one. Now let's go down to the injury and illness prevention program requirements. We've listed all the basic requirements for an accident prevention program. So you as an employer, you have to have this program that's set up to prevent these types of accidents. And we have listed out that what that type of program might include. You want to highlight the second bullet point that states you want to have a system for identifying and evaluating workplace hazards. So you need to have a system in place so you know what potential workplace hazards are out there. And the last bullet point you need to highlight, it states prevention program to include periodic, or at least every 10 days, toolbox or tailgate safety meetings of supervisors with employees. So at least every 10 days, you have to get your other supervisors out there to host these tailgate safety meetings with your employees to go over safety issues with them. Now, on the bottom of page 35, let's go to emergency medical services. The job site must also have at least one first aid kit in a weatherproof container. So you've got to have a first aid kit in some kind of container that's not going to get messed up by the rain, the dirt, snow, whatever else. And the contents of the first aid kit must be inspected regularly to ensure that the expended items are promptly replaced. So you can't have a first aid kit that's been ran through and doesn't have anything in it. You actually need to set up a system where you have someone checking your first aid kit on a regular basis to make sure that everything's in there. The minimum first aid supplies must be determined by an employer-authorized licensed physician, or the employer can furnish the first aid kit with supplies according to Table 1512C in Title 8 of the California Code of Regulations. Note, a doctor does not have to be the one to restock a first aid kit, only to select the contents of the first aid kit. So you need a doctor to provide you with a list of the contents of the first aid kit. But an employee or supervisor can be the one that's restocking the doctor-approved items that go in the first aid kit. So let's turn to page 36. This covers a very important topic, personal protective equipment. Generally, PPE must be provided by the employer if it is required to be worn by the employee. So such as hard hats at a construction job site. Some exceptions are non-specialty safety toe footwear or non-specialty prescription eyewear. So we've got a list of 6 different bullet points. You want to highlight the second bullet point. It states that employees working in locations where there is a risk of receiving eye injuries, such as punctures, abrasions, contusions, or burns as a result of contact with flying particles, hazardous substances, projections, or injurious light rays that are inherent in the work or environment must wear face or eye protection. So if you're working your job sites in any of those types of places, you have to provide those glasses, goggles, whatever it is, to your employees, and they must wear that protection that you provide to them. So let's go down to the 4th bullet point. Employers must make hearing protectors available to all employees at no cost if the employees are exposed to an 8-hour time-weighted average of 85 decibels or greater. Employees must be given the opportunity to select their hearing protectors from a variety of suitable hearing protectors provided by the employer, and the employer must make sure the hearing protection is actually worn. So if your job site is somewhere where in that 8-hour timed weighted average is 85 decibels or greater, you physically have to provide the employees with this hearing protectors. So earmuffs, earplugs, things like that. And not only do you have to provide those to your employees, you need to give them a variety of these ear muffs or earplugs, and then actually make sure that they wear them. That's your responsibility. We're skipping page 37, but please read this page. It goes over the reporting accidents. And we're going to turn to page 38, which is the Cal OSHA form. So we have this provided to you so you can look at it and see what it is. Now let's turn to page 39. And on the top of the page, the section is investigating accidents and near misses. So these are accidents that happen at your job site, or near misses which are something that could have caused an accident but didn't. So you want to highlight the first paragraph under that investigating accidents and near misses section. It states, a thorough investigation of all accidents and near misses will help you determine why accidents occur, where they happen, and what the trend in accidents appears to be. Such information is critical to preventing and controlling hazards and potential accidents. The investigation should be in writing and adequately identify the cause of the accident or near miss occurrence. The primary goals are to understand why the accident or near miss occurred and determine what actions can be taken to prevent reoccurrence. So to prevent that accident or near miss from happening again. Let's go down to the bottom of the page. Hazardous substances. Now, an SDS is a safety data sheet. An SDS for a particular material provides information on fire or explosion potential, possible health effects, symptoms of overexposure, proper precautions and handling practices, necessary protective equipment, first aid procedures, and so on. Now let's turn to page 40. Employers must adopt a code of safe practices that will provide workers with information and training about hazardous substances. This is how to handle these substances safely under normal and emergency conditions. So you need to provide your employees with information on how to handle these hazardous substances. If an employee is exposed to a potentially toxic material, the employer must inform him or her and also keep the employee informed regarding the corrective action being taken. Employee medical and exposure records must be kept for at least 30 years. So you have to keep these records for a long time. Let's move down to the second paragraph. A contractor who discovers the presence of hazardous material during construction should immediately notify the homeowner and stop the work. So if you're working on a job site and you notice that there's hazardous materials out there, you have to immediately notify the homeowner and also stop doing the work. The owner is responsible for abating the hazardous materials and for notifying the contractor in writing that the abatement is completed. Let's move down to the asbestos section. Asbestos is the most common carcinogen in construction or demolition work. Persons who do insulation, plasterboard, roofing, siding, and plaster ceiling work have the highest exposure risk. Now let's move down to the third paragraph. Contractors must register with DOSH that they are working with asbestos-contained materials with 100 square feet or more surface area. They must also register with DOSH before applying for asbestos abatement certificate or C22 license classification issued by the CSLB. Let's move down to the fourth paragraph under asbestos. The unlawful removal, and you need to highlight this sentence. It states, the unlawful removal of asbestos is punishable by a minimum fine of $1,000 and the possible suspension or revocation of the contractor's license. Down the last paragraph on page 40, it states, an owner, employer, or contractor must determine whether asbestos is present before work begins on a project. The employer or contractor must always inquire whether asbestos is present in any building constructed prior to 1978. A contractor must stop work immediately and notify DOSH if asbestos is discovered after work begins. So if you're working on a job site and you see asbestos, you have to stop immediately and notify DOSH. Turn to page 41. Go down to the section titled Complaints and Inspections. It states DOSH must investigate a complaint charging a serious violation within 3 working days after the complaint is submitted. A complaint of a non-serious violation must be investigated no later than 14 calendar days after it has been received by DOSH. Let's go down to the 5th paragraph under Complaints and Inspections. You need to highlight that last sentence of that paragraph that states, an employer may refuse to permit a DOSH inspector to enter the workplace unless the inspector presents an inspection warrant, in which case the employer must allow the inspection. So if DOSH shows up with a warrant, you must allow the inspection. Let's turn to page 42. Now let's go down to the next section. It's titled Violations. During an inspection or investigation, an employer may be issued a notice or citation. A notice may only be issued for a violation that does not directly affect the health and safety of employees. Now below that, we listed how these health and safety citations are classified. Now I'm just going to cover the first one, the serious violation. You need to highlight this violation. A serious violation is one that presents substantial probability that a worker will be killed or suffer serious physical harm. You need to look over all the other violations as well. I'm going to turn to page 43. The top of the page, the maximum civil penalty for a serious violation is $25,000, and serious violations will always be assessed a penalty, while minor ones may be assessed a penalty. Now, page 44 is your glossary of the terms for you to go over and familiarize yourself with. And I know this is a lot of information and it crams short period of time, So go back and review this so you're prepared for your exam. Best of luck in your careers. Thank you.